Welcome to the YouTube channel of Legally Trust. This video is one of the series of educational videos that will be available on this channel under the category General Awareness.
Hello friends, in today's video, we will discuss on delisting of companies. Delisting of companies is governed by SEBI Regulations 2009, which apply to delisting of equity shares of all classes. A company can be delisted either voluntarily or compulsorily. In a voluntary delisting, a company decides on its own to remove its shares from a stock exchange, whereas in a compulsory delisting, the shares of a company are removed from a stock exchange as a punitive measure. Compulsory delisting. Under Chapter 5 of the Delisting Regulations, a stock exchange can compulsorily delist any equity shares of a company on any ground set out in the rules made under Section 21A of the Security Contracts Regulation Act. Under these rules, a stock exchange can delist equity shares on any of the following grounds. The company has incurred losses during the preceding 3 consecutive years and has a negative net worth. Trading in the securities of the company has remained suspended for a period of more than 6 months. The security of the company have remained infrequently traded during the preceding 3 years. The company or any of its promoters or any of its director has been convicted for failure to comply with any of the provisions of the Security Contracts Regulation Act, the Securities and Exchange Board of India Act 1992 or the Depository Act 1996 and has been penalized at least 10 million or has been awarded imprisonment of at least 3 years. The addresses of the company or any of its promoter or any of its director are not known or false addresses have been furnished or the company has changed its registered office in contravention of the provision of the Companies Act. The public shareholding in the company has come down below the applicable minimum level and the company has failed to raise it to the required level within the time specified by the stock exchange. If the shares are compulsorily delisted, the company, its promoters, and its directors of the company must offer to purchase the shares held by the public shareholders at fair value in accordance with the delisting regulations. Voluntary delisting. A company can voluntarily delist itself from all or any of the recognized stock exchanges where it is listed. If it delists from all such exchanges, it must obtain prior approval from its shareholders by a special resolution, with the public shareholders voting in favor being at least twice the number voting against. The company's promoters must provide an exit opportunity to the public shareholders by offering to purchase all of their shares at a price determined through a book building process. This exit price must be above a floor which is determined under the provision of the SEBI Regulations 2011. If the promoters are unwilling to pay the determined exit price, they can make a counter offer at a price which must be greater than the book value of the company. The company can be delisted only if after the tender offer, the shareholding of the promoter reaches at least 90% of the shares sought to be delisted. If a company is delisted, those shareholders who did not tender in the original delisting offer can still do at the same exit price until a period of 1 year after the delisting, in which case the promoters will be obligated to purchase such shares. If a company delists only from some exchanges and continues listing on at least one stock exchange with nationwide trading terminals, it does not need to give any exit opportunity to its shareholders. A company can also be delisted from all stock exchanges if, after an open offer made by an acquirer in terms of the takeover regulations, the public shareholding falls to less than the minimum stipulated for the company to be listed, and the acquirer decided to delist the company by following the process prescribed in the delisting regulations. A company's equity shares can also be delisted as a part of insolvency resolution plans under the Insolvency and Bankruptcy Code 2016. Trading in shares of a company can be suspended for, among other things, failure to comply with the SEBI Regulations 2015 or the trading rules of the stock exchanges. Hope the information contained in this video was useful to you. Thank you for watching.
Hope the information contained in this video was useful to you. We look forward to each one of your support and cooperation in making this initiative a success. For more details about the trust, do visit us at www.legalaidtrust.in. Kindly subscribe this channel and click on the bell icon to get the latest updates about various law-related educational videos. Thank you for watching us and have a good day.